thank you very much, Wale, for agreeing
much
to this interview, for being here with us. It's such a great pleasure to have you to talk about some of these key issues facing justice and accountability. What's the relationship between the African Union and the International Criminal Court right now? How does that relationship look?
Well, as I said today at the workshop, it's quite interesting that in the media, there's that perception that there's absolutely no relationship whatsoever between the AU and the ICC, and actually that's not true. There are issues that the African Union has disagreements. They have certain disagreements with the ICC on a number of substantive issues. But there is, at the technical level, a certain amount of cooperation. As I mentioned again earlier, we organize joint seminars every year with the ICC. We've established some contacts with some offices within the ICC architecture that allows for flow of information. But I would say the relationship is like any other between two organizations. You have your disagreements, but you still cooperate in certain areas.
What can be done both within the African Union and the ICC, or the International Criminal Justice world, to improve that relation, to strengthen that relationship?
The two institutions need to continue to communicate at different levels. I think it really hasn't happened, particularly at the member state level. So between the ASP and potentially the AU's policy organs, I think that is something that could be improved upon. I think there's certain proposals that have been put forward by African member states in terms of amendments. There have been certain calls on the Security Council in terms of deferral proceedings. I think all that put together has not helped. I think there needs to be an open and honest conversation on these issues and an honest conversation around those proposals and how they can move forward. I think if those two things are actually addressed to a certain extent, not 100%, but I think it might improve the relationship.
How central is the issue of the UN Security Council to the ICC Africa relationship?
I think it's crucial. I think it's if you're looking at how the issue evolved, the negativity in terms of the relationship, it actually started because the Security Council refused to consider a request from the African Union, first the Peace and Security Council, and then the Assembly of Heads of State, calling for a deferral of the proceedings against one of the sitting presidents. I think that a reform of the UN Security Council and possibly even removing its powers under the Rome Statute is something that we need to discuss. Or a greater role for the G8 if, say, the Security Council cannot take a decision. So those are some proposals that I think that have come from African states that, again, have been ignored in the past, but potentially could address that negative perception in the relationship.
There's a real richness of justice and accountability measures and processes. The continent is not a blind spot for accountability for these crimes. There's a lot going on beyond the International Criminal Court. Can you highlight some of the key issues that you see most recently in terms of justice and accountability for international crimes on the continent?
Okay, I'll probably pick three. The first, of course, is the Hissène Habré. And of course, that's because it's more or less a concluded process to a certain extent, where the former president of Chad has now been convicted for certain crimes that were committed during his term in office, no matter how long ago that was. And I think that was a landmark mechanism, the extraordinary chambers in Senegal, which was set up between the African Union and the Senegalese government to prosecute the former president on behalf of the African Union. In addition to that, the AAU just adopted the statutes for the Victims' Trust Fund, and put in about $5 million. Now, of course, the court ordered reparations amounts to about $165 million. But by putting a token $5 million, I think the AU member states recognize the importance of victims' justice and ensuring that they're actually compensated for the crimes that were committed against them. Another important mechanism we're trying to put in place is the hybrid court for South Sudan. And of course, the basis for that was a decision of the Peace and Security Council calling for the establishment of this hybrid mechanism. We are at an advanced stage of concluding that process with the government of South Sudan. And it is our hope that we will be able to put in place this mechanism, this court, within the next few weeks or months to deal with some of the alleged atrocities that are being committed in that country as we speak. The last, of course, is the Malabo Protocol, of course, which was adopted in 2014, and this would create a permanent African criminal court, expanding the jurisdiction of the Court of Justice and Human and People's Rights to include international, not just international crimes, but also transnational crimes. And I think that mechanism would be a very important player in terms of addressing accountability, rule of law, and justice on the continent. Yeah.
Great.
Those are three major mechanisms off the top of my head. Yeah.
Thanks, Wale. In terms of the hybrid court, what are the major challenges you see in actually instituting it? And is there the possibility that the court could be set up without the consent of the government of South Sudan?
It is a hybrid court, so of course, there's still a debate over what that means. The hybridity, is it just in terms of the jurisdiction? Is it just in terms, or what is the role of the government? And I think all mechanisms of this nature face probably similar challenges. One major challenge, of course, for the hybrid court is that you're still in an ongoing conflict. So that would, of course, affect investigations or even how you want to go about setting up and ensuring that you get cooperation of all the stakeholders. I think financing possibly is another issue we need to think through clearly to ensure that there's sustainable funds for the hybrid court. Right. Lastly, most importantly, making sure we just have the right personnel around the continent, people who understand the context of the conflict, but are, not also too involved in the conflict that would create a problem.
But where is the Malabo Protocol right now? How far, or how close perhaps, are African states actually enacting it and ensuring that this African criminal court exists?
Unfortunately, as we speak, we have just about 10 signatures and no ratification. Some countries have committed to ratifying it pretty soon. As you may be aware, the heads of state endorsed a plan of action that was adopted by a ministerial committee to drive the ratification of the Malabo Protocol. So we're still a bit far off. When we look at the average time it takes an AU treaty to come into force, which is the 15 ratifications, about 5 years. Malabo was adopted in 2014, we're about 4 years, so we're almost getting there. So I think a lot more needs to be done, not just by the AU, but by the member states themselves in owning this mechanism, signing up and ratifying it. Hopefully sometime soon we should get the 15 ratifications and even more sometime during the year.
Great, thanks. There has been also criticism regarding the possibility or the amendment to the Malabo Protocol with regards to the potential immunity for sitting heads of state and senior government officials. Is this a problem? Where do you envisage that going? Is it an issue that you think will be addressed? Is it a permanent part of the Malabo Protocol? Is it a problem or not? How should we think about it?
Sometimes I think we are focusing on the wrong issues. The immunity provision in the Malabo Protocol is more or less a reflection of what we have in most member states' constitution at the national level when it comes to criminal prosecution. So most heads of state are immune from criminal or civil action while they're in office. And as such, I think the focus rather should be on the new crimes that have been introduced in the Malabo Protocol. Primarily because when you look at the transnational crimes, the impact of those on our communities are far larger than the impact from the international crimes, which are largely perpetrated by state actors. But the transnational crimes are perpetrated by non-state actors. And that's more pervasive in our society. So there's no instrument that is perfect. I believe that the discussion should continue on the debate, but I don't think it should stop member states, partners, and other stakeholders from actually supporting this mechanism, because to a large extent it would deal with issues that the continent really needs addressed.